I just remember her facial expression. It was kind of like a look of shock.
Once you heard the shooting, what did you think that was?
I knew it was a gunshot.
How many times was she shot? How many gunshots did you hear?
I thought I had died.
Do you have any opinion on whether Dr. Parker could have foreseen JD's actions that day based on the information that she had?
I think it would be difficult for anyone to have foreseen that.
We're counting down to the closings in the civil trial for the teacher who was shot by her 6-year-old student. Court resumes in just hours. Plus, deeply disappointed and disturbed, convicted killer Alec Murdaugh is blasting the new Hulu series about his life. And bond or behind bars? Well, we'll find out this morning if OnlyFans model Courtney Clenney will be released from jail ahead of her homicide trial. Also this hour, convicted killer Brian Kohberger refusing to pay up. The victims' families are fighting for restitution. We'll talk about what we can expect later today at the hearing. It's all coming up next for you right here on Opening Statements. Good Wednesday morning to you. Welcome to Opening Statements. I'm Julie Grant. Are you ready for some coffee and some court? This is the time where we get you all warmed up and ready to go for the big day ahead on Court TV Live. And what a big day it's going to be. So let's talk about it. Grab that cup of coffee right now. It's time for my opening statement. Cry me a river. Alec Murdaugh is deeply disappointed and disturbed by the new Hulu series about him and his family. He finds the depiction of their personal family dynamics to be particularly troubling. Really? You don't say. I know what's more troubling. Alec Murdaugh murdered his wife Maggie and murdered his son Paul. He stole millions of dollars from his clients and from his law firm. He manipulated, deceived, and defrauded some of the most vulnerable people in our society. He abused his power and disgraced the solicitor's office and the legal profession overall. Those things are more troubling to me than how he's depicted in the Hulu series. And by the way, when you go to prison for murder, you shouldn't be able to watch Hulu. Alec Murdaugh has nobody to be upset with but himself. He made his own bed, now he has to lie in it. His name was mud long before the Hulu series was ever even a concept, because he murdered Maggie and Paul and stole from people who trusted him. He is a manipulative, dangerous monster who's such a terrible person, he should be under the prison instead of inside of it. That's my opening statement on this Wednesday. Let me know if you like it. Right now, time for your daily docket.
Actually, done.
Okay, fine.
Done. Because you're costing me money. I didn't do because I got to this house because of you.
You let my mom say some line that.
No, because of you. Flirting with like 3 girls the whole time.
What 3 girls?
In Florida, we've got OnlyFans model Courtney Clenney with a bond hearing this morning. It's going to begin at 9 a.m. Eastern Time. We're going to bring it to you live. And in Idaho, we've got Brian Kohberger's restitution hearing set for today at noon. His defense attorneys are objecting to the state's request for additional money to be paid to the victims' families. And in Virginia, we've got the civil trial for the teacher who was shot by a 6-year-old student. That resumes this morning. Closing arguments set to get underway around 11 a.m. Eastern Time. And that is our top story. So what do we need to see in closings today from each side? Teacher Abby Zwerner is suing Ebony Parker, the assistant principal at Rich Neck Elementary School, for $40 million. The plaintiff alleges that Parker failed to act after being warned several times that the student had a gun. The defense began its case on Monday. Here's Dr. Amy Klinger with the Educators School Safety Network.
Do you have any opinion on whether Dr. Parker could have foreseen JD's actions that day based on the information that she had?
I think it would be difficult for anyone to have foreseen that. I think the actions of everyone involved indicate that they were doing an analysis, but yet that they did not perceive this to be a plausible, imminent threat, both the behaviors as well as the actions, because it is a 6-year-old having access to a weapon and bringing it to school, and it is largely unthinkable and certainly unprecedented in terms of the outcome.
Defendant Dr. Ebony Parker did not testify. So let's talk about whether that was a smart move and whether the defense case overall was strong enough. Let's welcome in our legal eagles, Casey Early and Franz Borchardt. Good morning to you both. All right, so let's start with Dr. Parker not testifying. What do we think about this move? Casey, would you start us off, please?
Good morning, Julie, by the way. I am kind of concerned, and here's why. Because we know that there were criminal proceedings that actually will go forward next month. I'm concerned why, or if the attorney filed a motion to stay the civil proceedings until the conclusion of the criminal proceedings, because we have the ability on the criminal side to invoke our constitutional right to remain silent. And on top of that, we also have the added benefit of the jury instructions that state that you are not to infer or imply that the defendant's right to remain silent is some admission of guilt. But you don't have that on the civil side. There's case law that states that you can file the appropriate motion. But even here in civil, she still could have testified. It's not a blanket assertion, but she could have asserted that privilege on a particular question. So I'm concerned, but maybe if she would have done that, maybe the jury would know, maybe there's a criminal proceeding and she must be guilty. So it's kind of hard to answer that question, but as the defense attorney, I would have filed all the appropriate pretrial motions because the standard on this case is way lower. It's the preponderance of the evidence, and that's the lowest standard. It's more probable than not. So based on just the testimony of the expert witness, I don't think this is a strong enough case, and this plaintiff's case was overwhelming.
Casey, thanks. Franz, what do you think about this defendant choosing not to testify?
So I'm a criminal defense attorney, Julie. So it's not that I don't care about money. I love money. But when it comes to civil cases, the criminal constitutional right to remain silent trumps, in my mind, in my world, the desire or willingness to testify in the civil. I think it's the right move for her not to testify. I wouldn't have put her on the stand. And look, I agree with Casey. Generally, these civil trials don't happen until after the resolution of the criminal case. Generally, we file a stay, or even in the absence of a stay of a trial, everybody understands that it's not fair. It's fundamentally not fair to those individuals being prosecuted to also be in a box to where they cannot testify in the civil, or they have to invoke a constitutional right where the jury will inevitably draw some kind of inference that, well, if you're pleading the fifth, you must have done something right or wrong, excuse me. So I think it's the right call. And candidly, does she even need to testify? I mean, there's enough that came out on her defense side, to at least put words in her mouth as to what she would have testified to. So would a jury want to hear from her? Sure, but I think it's the right call.
Appreciate it, Franz. So something that one of my Court TV colleagues shared as we prepare for these trials and do research, Virginia law states that prosecutors cannot use testimony from a civil defendant in the criminal trial unless they perjure themselves. So that being said, let's just do the analysis, assuming that this legal research, which again, a colleague of mine did, I did not do this personally, I do not practice in Virginia. Let's just assume it's correct for purposes of our discussion that she can't be penalized in any way in criminal court. It can't be used against her. And as long as she tells the truth, and let's assume she does, we're all good. That being said, does it change your opinions about whether she should have gotten up there? Franz, you're shaking your head. Why not?
So it's 2025. I'm imagining potential jurors in the criminal case sitting with a box of popcorn watching court TV, glued into Julie because, I mean, hello, host with the most. I mean,
love you.
So I imagine, right, I imagine scenario where people are seeing her testimony and then judging her testimony in the civil. It may not be quote unquote admissible, but it's 2025. We are a globally digital platform. I don't think it changes anything for me. I think she doesn't testify. I don't think she and by the way, unless she perjures herself, basically means anything she says in the civil case, she's locked into, and anything she says differently, if she were to testify in the criminal case, all of a sudden becomes perjury or impeachable. So I think my answer is still no, Julie.
I appreciate it. Excellent points you made, Franz. Casey, has your mind changed at all with that protection?
I still think, based on the facts, she still should have testified. She can explain, because even though there's testimony as to what she allegedly did, maybe she can provide extra explanation that based on the circumstances, based on her experience with the child, that's not how the conversation went, or I did these steps. Explain what you did versus what everyone is saying you did not do. And just like the expert testified, was this foreseeable? That's going to be something that the jury is going to have to deliberate on. But I believe in this case, she still should have, because as a juror, I'm looking at all the other testimonial evidence, and I'm saying, well, I have questions, and they haven't been answered by that expert.
Right. I'm trying to think of it from the perspective of the jury myself as I look at this. I want to hear from her, especially if I'm on that jury. You know, she's a doctor of education. Obviously, this is a very intelligent woman. You don't get that position unless you're intelligent, hardworking. You know, there are probably things about her the jury wants to hear more about. So on this incident, what happened? Where was your brain, you know, when all this was going on? You know, I think the jury is going to have a hard time not hearing from her, having her sitting there. You know, in that video, the video does not look good when she's sitting there. And she looks very casual that day. Maybe it was like a casual Friday or something. She has on like a hooded sweatshirt, and she's at the desk, and there doesn't appear to be a lot of, you know, urgency. And it just, you know, look, she just kind of is sitting there staring. So I think she could have explained this, how she's looking, and offered, you know, some kind of an, you know, apology, regret, some kind of remorse to this jury. We expect the closings to start at 11 a.m. So let's end on that point. In terms of what each side really needs to hit home, would you both do me a favor and take a side just for the sake of this analysis and kind of highlight the big thing you would want to get across? Franz, do me a favor, take Dr. Ebony Parker's side, not taking the stand, how you might explain that, because you feel very strongly that she shouldn't have testified. Casey, do me a favor, take Abby Zwerner's side here. So what are going to be the big things you're going to say when it comes time for the close, like one main point? What is it? Casey?
Ladies and gentlemen of the jury, there were multiple announcements, there were multiple concerns that was brought to the defendant, and multiple omissions. Nothing was done in this case. And they can easily say that, Julie, because they didn't hear from the principal. And just like you stated, the plaintiff can also infer or tell the jury, you can infer that her not testifying today is another continuation of her omission. And I think that this will be a great closing argument for the plaintiff to show that she did nothing then and she did nothing now. So it definitely ruled in a favor of the plaintiff.
Yeah, that's good. Multiple concerns, multiple reports. That's good, yes. All right, Franz, help us out. Defend Dr. Ebony Parker here.
The best witness in this case, the best, most truthful witness in this case is the policy and procedure which the jury heard expert testimony state it was followed and it was unpredictable. This situation was unpredictable, and candidly, my client doesn't have to testify to affirm that. In fact, the testimony that the jury is getting, Julie, is far better than my client testifying to that. So she didn't take the stand because, candidly, the policy and procedure, which is supported by expert testimony, speaks for itself.
Ooh, that's good. It's in writing. Point to the policy. She doesn't have to say it. It's right here. I like that, Franz. All right, we'll see what happens. Approximately 11 a.m. Eastern Time. Franz Borghardt, KCA Early. Stand by, please. We'll hit a break. When we come back, here's what's next on Opening Statements.
Indictment for murder, guilty. Indictment for murder, guilty.
Justice was done.
It gave a voice to Maggie and Paul Murdaugh, who were brutally mowed down and murdered. We can't bring them back, but we can bring them justice.
And he may be taken away.
Convicted killer Alec Murdaugh not happy about the recent Hulu series about him. Plus, will OnlyFans model Courtney Clenney get out of jail today? We'll find out in less than an hour.
Here you are, responsible for the lifelong torment of an entire family. Is that evil in your mind now? So now you've taken her mother's life, and you heroically step in to console her.
I knew it was wrong, but yeah, I still did it.
Did you murder her mother to try and drive her back into your arms? Oh my God.
Interview with a Killer. New episode Saturday night at 8 Eastern and Pacific, only on Court TV.
Welcome back. Alec Murdaugh is trending yet again as the convicted killer is responding to Hulu's newest hit series centered around the murders of his wife Maggie and his son Paul.
This is Alec Murdaugh. I need police and an ambulance immediately.
Looking back, sometimes I feel like living a life I never was supposed to live.
Murdaugh, Death in the Family, released on streaming platforms last month, and now Alec Murdaugh is slamming the popular drama by releasing this statement from behind bars through his attorneys, Dick Harpootlian and Jim Griffin, saying in part, quote, Alec is deeply disappointed and disturbed by the recent Hulu streaming series about him and the entire Murdaugh family. The program contains numerous inaccuracies and misleading portrayals that distort the truth of their lives. The depiction of their personal family dynamics is particularly troubling, as it totally mischaracterizes Alec's relationship with his wife Maggie and his son Paul, both of whom Alec loves so dearly. There's more. The statement adds, no one from Hulu ever reached out to Alec, his son Buster, anyone in the Murdaugh family or Alec's attorneys to hear their perspective or verify the facts. Instead, the program appears to rely heavily on sensationalized accounts from secondary sources. Murdaugh's camp also says that viewers should treat the series as fiction. All right, so what's your reaction to Alec Murdaugh's statement? Let's bring in the attorney who represented the family of Gloria Satterfield, who, by the way, is a key character portrayed in this series based on the Murdaugh family. Eric Bland, high-profile attorney, friend of the network, a podcaster with Mandy Matney and Liz Farrell, whose reporting is largely depicted. They are characters in this series as well. Eric, good morning to you. My reaction to Alec Murdaugh's thoughts is, who cares what he's saying? What's your reaction, please?
It's more of the same. This is not meant to be a Ken Burns PBS special on the Revolutionary War. It's based on true life shocking events and an award-winning podcast. So, I know Dick's upset, but sometimes this, happens when you represent a monster, and you also represent somebody like Paul, who was shaped by overindulged and undisciplined parents and how they treated him. What was wrong about this docu-series? Maybe they got it Tuesday or Wednesday wrong. Sure, the timeline with Gloria Satterfield dying was changed to kind of fit the narrative. But the overriding material observations and facts are clear. Alex is a monster. Alex abused alcohol. According to Dick's own words, Alex abused narcotics. Alex leveraged his relationships with the bar and with his father and with the dynasty of the family name. He used his position of authority to take advantage of people. He abused and used and bullied his banker. Those are the material facts of the case, Julie, and those are true.
You're so right, Eric. So right. Tell me, I know you're still in touch with Gloria's children, who were also seen in the series, or actors who played them as well. Have you spoken to them about what the series is like, whether they've watched it? What are their sentiments about it all?
They're just not people who watch these type of series, but they have followed a lot of the internet chatter, and they do appreciate the way that the producers portrayed their mother and their sister. As I've said all along, she was so much more than just a housekeeper, and you can see it in the series of how she was close with Paul and how dedicated that she was to the family. This is Hollywood, you know, this is art, this isn't science. And no matter how loud Dick says it or how many times he says it, Alex Murdaugh is a unique, once-in-a-lifetime monster, and he represented him. And here's a newsflash to lawyers. You better be careful who you represent, because some of that stink will turn over onto you.
Oh, that's good, Eric. That's good. You're right. Yeah. I mean, Alec Murdaugh, I agree. Such a unique killer. You know, I mean, for so many different reasons. It's like he was this monster hiding in plain sight who seemed to be the good guy. And I mean, not only was he a thief, he was a killer, he was a liar. I mean, preyed on the most vulnerable people in our society. And it's just, it's stunning. It really is. And having seen the trial, I'm loving the series. I think it's fantastic. And I'm not just saying that. I'm not just saying that because, you know, I know you and Mandy and Liz, and I think it's fantastic. And we've had Mandy on the show recently to talk about it and congratulate her, because I know it was, you know, her reporting. And Eric, correct me if I'm wrong, is she one of the producers on the series too?
She is. She's a contributing producer. She obviously didn't have first chair control,
Sure.
but it's based on her book, it's based on the podcast, and it's based on how the events unfolded. And unfortunately for Dick or Jim, this became a national and international trial, and there was a deep dive into Alex. And this was a very troubled family that something like this was destined to happen. I mean, they, you know, in the beginning, you don't like Paul, but in this, as the series progresses, you feel sorry for him, because he was the product of parents who tolerated bad behavior. They drank in front of him. They let him drink. They let his personality get out of control. And you feel bad for Paul as a parent.
You're right, Eric. You do. You do. And I think the series portrays that well. You know, he was shaped by his circumstances, his environment, his parents. I have a clip I'd love to play for you now. This is from the Murdaugh Death and the Family podcast, and we're going to see Mandy Matney with Brittany Snow, the actress who plays Mandy in the series.
I think the people that still don't believe that he did it, I think it's because nobody wants to, because it's just too horrific to imagine. And people always love to say, like, well, the motive doesn't make any sense. And I'm like, motives shouldn't make sense. Like, motive for murder should never really make sense to anybody.
Yeah, it's great seeing them together. She looks so much like Mandy in this series. I encourage anybody to watch it. If you have Hulu, I think you'll find it very entertaining. So, Eric, going back to the story, which is portrayed well, and where we are right now as the episodes are dropping, we're getting to the point where, you know, Mandy latches on early that there's a story there. She sniffs out the story and really starts digging, as you know, and becomes kind of a thorn in the Murdaugh side, so to speak, because she's a reporter doing a great job and paying attention. And so now I'm wondering, with Murdaugh, you know, crying behind bars, oh, you know, this is unfair, the series, blah, 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 whatever he's saying. It's like, I kind of expect this, don't you? Because, you know, look, this is largely, you know, Mandy's work that shined a light on all of this. So I kind of feel like he would try to say something negative.
Sure, the family operated in the shadows in the dark for so long, and after the boating accident, everything came to light, and it makes perfect sense that a reporter like Mandy is going to dig deep. Look, how does Alex even watch Hulu behind prison? I highly doubt that he's able to see the series. He's probably told about it. But two, it is accurate. He did these things. He did steal money. He did abuse alcohol. Dick Harpootlian got on national TV and said he was a rabid drug addict. So all of these things happened. He did not treat Maggie with the respect that a wife deserves. What more do they want? You know, so you get an outfit wrong or a day wrong or whatever. That's not material. You can't say gotcha because of that.
You're exactly right. And that actor, Jason Clarke, who portrays him, wow, is he good? He is sensational. I hope he wins an Emmy. Eric Bland, always a delight to have you on the show. Thank you so much. Be sure to check out Cup of Justice, Eric's podcast with Liz and Mandy. We'll see you soon. And coming up next on Opening Statements.
What do you want to say?
I want to be like, exonerated, I guess, of like anything wrong. And I want him, okay, the police are here. I want a restraining order against Christian Abumseli.
So will OnlyFans model Courtney Clenney get out on bond today? That's what her attorneys are asking for. Plus, killer Kohberger fighting the victims' families over money. We'll talk about what we can expect today at the hearing.
Like, I have not always been the victim, but like right now I'm the friggin' victim in the situation.
He and the defendant, Clenney, had been involved in an extremely tempestuous and combative relationship.
Don't touch me!
What is going on?
He had my neck, and this happened twice before, where I couldn't breathe.
I was sober for 2 weeks. 2 weeks. And now why am I not sober? Because of you.
In our spotlight this morning, OnlyFans model Courtney Clenney in jail for more than 3 years, awaiting her trial. She's accused of murdering her boyfriend, Christian Abumseli. Her defense team is saying that she acted in self-defense when she killed him. So this is a questionable homicide case. And now, today, the question becomes, should she remain in jail while awaiting this trial? So the incident in question happened during an argument at the Miami condo that the couple shared back in 2022. Courtney Clenney's claim is that she threw a knife across the room and it hit Christian Abumseli in the chest in self-defense. The prosecution says that she plunged the knife into his body and that it was a murder. I want you to take a listen to what her attorney, Frank Prieto, said in court, talking about all the delays in getting to trial.
We need to get this moving. Again, Clenney's been in custody now 3 years and 2 months. It's time to get this in a realistic trial date position.
All right, so she's expected to be in court in less than an hour from now, and we're going to go in and watch that hearing live together. We should expect some fireworks in the attorney arguments if past hearings are any indication. So should she get bond, and what are the arguments that should be made to support that if you're on the Clenney side? Let's talk about that with our legal analyst guests, Casey Early and Franz Borghardt here. All right, so we know that they're going to bring it today. Frank Prieto and Sabrina Puglisi are heavy hitters in Miami. They've come on the program many times. And what do you think would be the most convincing argument that they could make today, here and now, 3 years, 2 months in, and still there is no trial date for Courtney Clenney? Franz, would you start us off, please?
So I think you have to start from the position of what's taking so long. Why are we not in trial already? She has a constitutional right to a speedy trial. Yes, the state of Florida has the right to hold her while she waits for trial, but not indefinitely. And at some point, you have to get off the proverbial pot and you have to try the case, or you need to let her out. And I think I think at 3 years, the case starts getting a little ripe and a little stale, and it's a good reason for lowering the bond. And many states have speedy trial laws that say if you don't try it within a certain amount of time, they're relieved of their bond obligation. Now, you can lower the bond, give her some safeguards, put a monitoring device on her. But I think at this point, there's a strong argument, Julie, for what is taking so long.
Definitely. That's an excellent point, Franz. Yeah, and I really like what you said about safeguards, because when we look at the candidate, bond is to secure an appearance, and we need to be looking at, is she a danger to society? Is she going to flee? Are there things we can do to keep her in a place where she's not going to go anywhere or harm anybody? Casey, tell me, what do you think is the strongest point you can make to the judge if you want bond for Courtney Clenney?
Well, the judge obviously is going to look at many factors. They're going to look at whether or not she's a risk to the community, a danger to the community, a flight risk. They're going to look at her criminal history and all sorts of issues, whether the crime, and we know, was violent. And then the judge is going to make a determination. So obviously the judge had already heard previous arguments, because usually before a motion to modify bond, there's a bond here, an author hearing, proof evident, presumption great. And then the second prong is whether or not they considered those factors and weighed it in the interest of justice as well as safety to the community. But also, Julie, I want to just state, I practice in Florida, and a defendant has so much power, but it's channeled through the attorney. So if she's been in custody for 3 years, there is a thing called demand for speedy. I file them all the time. I love the power that I have. When I'm ready for a case, if my trial is ready and I've done over 100 to verdict, I file a demand for speedy. It gets the clock ticking. And then after that time is up, we file a notice of expiration. And you know, the greatest gift that we get, if the state is not ready, if the court isn't ready based on just cause, then we get a dismissal. So really going back and forth telling the judge, you know, you're taking too, no, I control the judge's docket. I file when I'm ready. So the real question should be, why, if the defense is ready, why haven't you filed that demand for speedy? We have the power.
It's an interesting point you raise. You know, it's something that we can certainly ask Frank and Sabrina. They've been very forthcoming and open about this case. They come on the show often. There have been issues. I know they were trying to get prosecutors thrown off the case for unethical conduct, for going into privileged communications. So I know that was a whole thing. And then Frank and Sabrina came on the show the other day and shared something brand new. They always seem to share something new that they're finding out as their team digs deeper. Let's take a listen to what they shared on opening statements. This was maybe about a week or so ago. Let's watch them.
We found out in a collateral proceeding that a witness, the first person to enter Ms. Clenney's apartment, was videotaping on his phone and taking pictures. And after the police were interviewing him, they instructed him to delete all his videos and all the photos, which was the pristine alleged crime scene. So this is new evidence that I think the court needs to consider that this would have been helpful for the defense.
Whoa, that's not good for either side. Who knows what would have been on that witness's phone? Apparently it was someone at the apartment complex who started taking video evidence of the scene, and then a patrol officer tells them, get rid of it. Franz, what weight, if any, do you think the court will give that today?
So it certainly falls into, I mean, is it directly exculpatory? Maybe not, but it doesn't pass the smell test. And again, look, the reason Casey is being very nice, the reason they haven't filed the speedy trial motion is they don't want to go to trial. They just want to get her out. The longer this goes on, the better it is for her. The more issues that are created, and the more issues that are created, and Julie, you know this as a former prosecutor, the more issues that are created, the more chaos. And chaos is generally the best friend of a defense attorney. So they don't really want to go to trial. They just want to get her out. And I think this is a good issue. And with enough issues, sometimes that leads to a favorable resolution. So I like it. I like this issue, and it doesn't work well for either side. And if I'm a prosecutor on this case, I don't like that at all. Why are you messing up my case?
Right. You know, speaking of the prosecutor, so let's take a listen to what this attorney representing the state of Florida said at the last hearing when the defense team brought up bond.
Are you going to respond in writing to the reconsideration of the bond?
So, Judge, that's the hard part about this, is that there's not much that's new within this. There are, they're asking for reconsideration based off of the amount of time and the litigation that took place really over the last 18 months. It doesn't change the risk of flight, the dangerousness. It doesn't, I honestly don't believe that there's any form of evidentiary hearing that would be necessary. And it's one of those that certainly if Your Honor believes I should respond, I'm happy to. But I don't believe there are grounds in this to warrant the defendant's release.
Okay, so again, we're in Miami-Dade County. Kesia, you're familiar, you practice in this area all the time. So how do judges typically lean with a case like this, with someone who's accused in a homicide, and it's questionable whether it was done illegally, unlawfully, or if it was done pursuant to self-defense legitimately?
Yeah, I'll be there tomorrow, by the way. Typically, when a judge makes a ruling for a motion to set bond, they typically don't change or move from their position unless there's a substantial change. And usually, in all my cases, only have one murder case where the judge allowed my client, because it was an agreement between the prosecutor and I. But you know how we reached that agreement? I continue to investigate. I poke holes at the prosecution's case, and then I convince them, look, this is weaker and weaker as we go by, so take the depositions, do your investigation, because usually either you reach this agreement or you go back to the judge. I had a case before where my client was in for almost 3 years. We finally had the opportunity to take a deposition of the alleged victim, caught her in so many inconsistent stories, took that transcript to the judge and argued for release, because I truly believe that the state can improve their case. So you have to come with something more other than, oh, she's been in for 3 years. Okay, I made my ruling. If there's no additional facts and circumstances or evidence, then the ruling should stand.
Really great conversation with you both. This is also helpful. We'll see what happens in just a short time when Ms. Clenney appears before the judge. Kesia Early, Franz Borghardt, you both have cases to win. We got to let you get off to court. Thank you so much for being on the show. When we come back, we're going to talk about killer Kohberger not wanting to pay up. That's next. Covering the country's biggest trials before we bring you inside the courtroom. Plus, the true crime cases you want to know more about in our daily spotlight.
Opening statements with Julie Grant. Mornings at 8, 7 Central on Court TV.
Did you murder her mother to try and drive her back into your arms? Oh my God.
Interview with a Killer. New episode Saturday night at 8 Eastern and Pacific. Only on Court TV.
Now for what's tipping the scales of justice. He murdered their children, but Brian Kohberger seems to be offended at having to pay additional compensations to the families of the victims. What? How low can this guy go? Kohberger's fighting to pay court-ordered restitution to the relatives of the young people that he murdered. So why? When a court filing, his attorneys say that he shouldn't have to pay. They say because the families received GoFundMe money, somehow that absolves him. And they add that because he's not working, he's imprisoned, he can't meet the sum of money that's been ordered. Well, he reportedly owes about $300,000 in fines and restitution payments combined. So how is this all going to shake out? And what about his attitude? What does it signify, the attitude of I won't pay, I refuse to pay? I find that offensive, don't you? Let's bring in criminology expert, author, and professor at St. Thomas University, someone who has followed this case from the inception and given us tremendous analysis on it, Dr. Debbie Goodman. Dr. Debbie, good morning. What do you think about this animal not wanting to pay up?
Good morning, Julie. It's just, again, astonishing, shocking,
every level and layer of this case, as we know, we've been talking about it for 3 years. There's just been no decency, Julie, no humanity. And here we are, it continues. So restitution should absolutely be a mandate. It's designed really for a dual purpose. It is supposed to be punitive for the defendant to have some level of penalty, and secondarily, to hold one accountable. But you know what else is interesting, Julie? As you know, and we can remind the courties, there's a third area of restitution that doesn't get a lot of attention, but I think it's worthy of discussion today. And that is, if the defendant has taken something wrongfully from the victim, it is supposed to be returned. And so, although we don't know 100%, as a criminologist, I'm 99% certain that this individual would have taken something of the victims from the home on King Road, and whatever that is, it should be returned as well.
Oh, that's fascinating, Professor. Well, thank you for that. So, thinking about the idea that he's imprisoned, I want to talk about this. So he's in prison, and as you know, Dr. Debbie, prisoners can have jobs. You know, they're not going to get rich on those jobs, but they get paid a sum. I think that any sum of money, even if he makes 2 cents an hour, I feel like even those 2 cents would be meaningful to the victims, and he should still have to pay it because it shows he's working and doing something to try to offer some measure of making this right, even though there's no way to ever make it right, but there's just something being done with him. What do you say to that?
I say you're 100% right, Julie. I agree. 2 cents, 1 cent, whatever it is, for the rest of his life, he needs to be working toward paying back these families. What he has done, Julie, is just going to shock all of us for the rest of our lives. And we can only imagine the levels of despair and destruction. He destroyed these families by taking the lives of Maddie, Kaylee, Ethan, Zaina. So I absolutely agree that from today on, it has to be a requisite, it has to be a mandate for him to continue living his life. And if some way, somehow it's not, I would say we need to renegotiate, and it's got to be looked at again. His status, he is alive. And while he's alive, he needs to be paying every single day, whether it's a penny, whether it's a nickel or dime, for the rest of his life toward these families for restitution.
Yes, Dr. Debbie. I want to ask you, please, about his personality, because I know you've seen many cases, as have I, where, you know, defendants are going away to prison and everybody knows they're not going to be able to pay the sum of money that's ordered. But yet they go along with the ordering of it. They don't challenge it, I think, because they know, you know, you can only do so much behind bars, but it's more symbolic. Sometimes it's just the idea that they're being ordered to do this and they can potentially get a job and procure, you know, something toward the amount that's owed. Here, the fact that he's putting forth a challenge, I just find so sickening. What does that say to you about his personality?
Yes, Julie, sickening is the right word. I find it sickening. I find it shocking and startling, quite frankly. And what does it say? It again, Julie, goes back to all of the things we have been discussing about him in the past 3 years. And by the way, as you well know, and your team and the courties, November 13th, we're a week away from the anniversary of this terrible tragedy of 2022. But it speaks again, Julie, the narcissism. He's a psychopath, very manipulative, very, again, self-grandiose. We can only imagine him in prison. We know all of the laundry list of complaints he's had. I mean, it's unbelievable. And I hope today becomes a restitution resolution.
Oh, I know you do. You've been such a great advocate for those victims. Dr. Debbie Goodman, thank you so much for your expertise. Always a delight to have you on this show, and a delight to have you at home.